Hello, welcome to OLA 2020. This session is titled Copyright and Distance Education. My name is Casey Lowry. I'm a member of the University and College Division of OLA, and I've got two copyright experts here with me, Kristen Burkholder and Clark Yakovakis. They're going to start us off with a brief introduction, and then we'll get into some Q&A. Take it away. Kristen, you want to go first?
Burkholder. I'm the Access Services Librarian at Delaney Brown Library at Oklahoma City University, and I've been in this position for a little over 8 years now. Before I became a librarian, I was an assistant professor of history at Oklahoma State University in Stillwater, which means I've written a history dissertation, I've published a few professional articles and book reviews, and I also, out of personal interest, have written a lot of fan fiction over the years. So partly as a result of all that, copyright issues have been a long-time interest of mine. As part of my job duties as the Access Services Librarian, I'm also the go-to person in our library for general copyright questions. We have a big music program and we have a special music librarian. She answers copyright questions that are related to music and theater and performance. Copyright in music in particular is a little different from copyright in text, and so she has the more specialized knowledge on that, and I do the more kind of general copyright stuff. Personally, and this is my own opinion, this does not reflect the views of my institution, I think that current copyright law does not serve the purpose it was intended for. The U.S. Constitution in Article 1 says that copyright law exists, quote, to promote the progress of science and useful arts, end quote. So monetary compensation is not the primary purpose. And having extremely long copyright terms means that it is very difficult for new writers, so writers of a later time, or artists or composers or whomever, to create works that are inspired by earlier ones without feeling like they're at potential risk of lawsuit for copyright infringement. So I think at this point, the long term is actually counterproductive in terms of actually promoting the useful arts. Nevertheless, copyright law is what it is, so we as librarians do need to have some familiarity with it, at least enough that we can advise our faculty and our student patrons on how they can use copyrighted materials and remain within the law, or at least pretty well within the law. One really important thing to keep in mind when dealing with copyright questions is that the law is deliberately ambiguous and flexible. This is not a problem. This is the way it's supposed to be. And it can actually be to users' benefit, even though it makes dealing with questions about copyright more complicated. So not a bug, it's a feature that it is complicated and flexible. Another important thing for librarians to remember, especially when you're working with students, is that being on the internet, something being on the internet does not make it automatically public domain, which an awful lot of students seem to assume. Rather, it's the opposite. Current US law actually says that as soon as a work is in fixed form, it is under copyright to the creator. So that theoretically, technically, even includes things like blog posts or Facebook comments or tweets or, you know, your home cat video that you put up on YouTube and anything you can think of just about. So unless there is some kind of indication on that picture or that text or that video or that piece of music that it has been designated for Creative Commons sharing or that it's in the public domain, the safe assumption is that it is under copyright, and you need to then think about how you're using it. I have a couple of handouts that I created and that are going to be available on the OLA conference website with this recording. Exact location to be determined. One has a list of copyright issues to consider for fair use on one side of the handout and a list of 5 questions that anyone who is considering using copyrighted materials should go through on the other side. So that's a really hopefully helpful thing to give to faculty if they are trying to figure out if they can use a particular thing. The other handout has brief descriptions and links for a number of websites with further useful information on copyright, and it ranges from government pamphlets, and I want to give a shout out to Clark because he added a couple to my list. Thank you so much. There are some online tools and newspaper articles and just all kinds of information, so I hope folks find that helpful. And note that both of those handouts themselves have a copyright comments BY-NC-SA 4.0 license, which means that you can share them, you can adapt them. And all I ask is that you give me attribution, don't use them for commercial purposes, and then you need to put the same license on it as I did. So that's me, and I will hand it over to Clark.
Thanks so much, Kristen and Casey. My name is Clark Iakabakis. I am the Scholarly Services Librarian at Oklahoma State University. I've been at OSU almost 2 years now. Before that, I worked in a few different libraries in Texas in various capacities. Here at OSU, my copyright is only one of the my tasks, answering questions about copyright from students and faculty, ranging from everything, can I post this to course reserves, to I want to use this scale in my dissertation, how do I go about getting the permissions for that, and those kinds of things, all over the place. I first became interested in copyright when I was a graduate student at University of Texas. I took a course on legal issues in libraries taught by Gretchen McCord, who was a former Texas Library Association president and attorney. And it absolutely fascinated me. Following that, I read a book by Siva Vaidyanathan called Copyrights and Copy Wrongs, which is one of the most captivating books on copyright and all of its uses and abuses, both from creators and kind of pointing towards what Kristen was saying, some of the severe limitations of the law when it comes to using content, something that we're seeing right now all the time due to the circumstances where we really need to be able to flexibly use content in our teaching and learning. And so, yeah, and I really echo that the law has not been substantially revised since 1976, of course, before, when digital was just an idea. And it's had a few amendments like the Digital Millennium Copyright Act and the Teach Act, which I'm sure that we'll get into. But those, I kind of see those as the, so if fair use is the Dr. Jekyll, where it's flexible and you can use it in a lot of different ways and it's very robust, these acts are kind of the Mr. Hyde, where they're really complicated. It's a long list of criteria that you have to follow. It's not easy for us to interpret as educators and apply. And that is really inhibiting when we're trying to achieve the goals of a nonprofit educational institution. And I do want to put the asterisk on everything that I'm saying, that I'm not an attorney, and that everything that I say here is not to be considered legal guidance. Please consult with your legal counsel. But on the other hand, I do think that we as educators, as researchers, as content consumers in our everyday life, absolutely have the right to make interpretations of copyright law as we understand it, even if it's not, the same kind of binding legal guidance that you would get from an attorney.
All right, thank you guys. So let's start a little bit of a discussion. How about the very basic question of what's the difference between just having copyright on something and having like a Creative Commons license?
I'll go ahead and kick off. So copyright is the legal right which is granted by the law in a given country, so US law, that grants the creator of an original work the exclusive rights to its use and distribution. The copyright holder can then choose to allow others to copy or reuse that work or not, and can charge other people for the privilege if they choose. They don't have to. The copyright holder can also choose to attach a Creative Commons license to this copyrighted work that permits others to copy the work without charge, but potentially with certain restrictions, for example, not with alterations or not for commercial uses. But putting a Creative Commons license on your work does not mean that you're giving up copyright. A lot of people kind of say, oh, well, if I put a Creative Commons license, that means I don't have the copyright. That is not the case. What you're doing is you are making publicly known the conditions under which somebody can use it without having to request permission, perhaps without having to make any kind of payment. So Creative Commons kind of adds on to your copyrights.
Yeah, and just to add to what Kristen said earlier, the original intent of copyright is you find in the Constitution, promote the progress of science and the useful arts. And so this constitutional clause led to the development of the federal law. So that's binding legislation. But as Kristen said, Creative Commons is almost like a contract that the user enters into when they are using the content that the creator. So whereas copyright is all rights reserved, Creative Commons is some rights reserved. So it's a way of kind of getting around some of the restrictions of copyright when someone wants, for instance, their work to be shared widely. They and you can read the full contract on the Creative Commons site that says you must follow these guidelines. Another analogy to that, because it is a license or sort of a contract, is library ebooks or journals, where if the user violates the terms, they can potentially be held liable for infringement. And something people may not know is a film is the same way, where the creators or the production company, in most cases, licenses users, the viewer, to watch it in private settings, but they can't, for example, broadcast it to the neighborhood. So I think this is a great question to lead off with, because those kinds of distinctions are really important, and there's something that we're going to continue to come back to throughout the questions that you're asking us today.
Yeah. So what are some general guidelines that we typically hear about from copyright law? Like the 10% rule, what is that?
So the U.S. Copyright Office published guidelines for educators that give kind of minimum, you could say, not a ceiling, but a floor of how much of a content can be used for educational uses. So it's not to say that you may not exceed these amounts. You could potentially exceed the amounts and still be within the fair use guidelines, but it's kind of a threshold to help those of us in education to make copyright decisions without having to conduct a fair use analysis each and every time. However, it's important to note that in a court case, which may come up again during the course of this, where some publishers sued Georgia State University for infringing on copyrights in their course reserve systems. The judges ruled that these copyright guidelines are not binding. So what that means is they're not a part of the copyright legislation, and that really it's up to each individual making use of the content to conduct their own fair use analysis, which at first sounds kind of intimidating, because it's like, just tell me, can I put a chapter up or can't I? Can I use 10% or can't I? But at the same time, it also empowers us to make use of fair use, which we should all be making as full use of as possible.
Mm-hmm. Kristen, anything to add?
Yeah, I think Clark covered it really well, but I'll add that, 10% is a rule of thumb. It is not a law. It is not the law, as he noted. And there could be instances where using less than 10% would still violate copyright. Using only 5% might violate copyright if that part is sort of the heart of the work. You know, if you read this and you don't need to read any of the rest of it, then using just that part might have been violating copyright. And that is exactly why it's good to conduct that fair use analysis. On the other hand, it is a reasonably valid rule of thumb. And, you know, if you have a book with 12 chapters and you want to put one chapter on course reserve, you're probably going to be just fine. You know, because if you had to make the students buy the whole book, you probably would find something else. So it's not going to affect sales, for example, that kind of thing. If the library owns the book, you could put the whole book on course reserve. They just read that one chapter. So yeah, so it's a good guideline, but it's just a guideline. It's not the law.
Right. So are things that we create, like as librarians who work at universities, are things that we create owned by our employer, or are they owned by us if we're creating them for work?
Oh, I'll go with that one. If you are a U.S. government employee and you're preparing the work as part of your job duties, that is a work for hire. So if you were a librarian working for the Library of Congress and you wrote an online guide for how to search the Library of Congress catalog, that would be a work for hire. You would not hold the copyright. The Library of Congress would have the copyright on that. However, very few librarians in Oklahoma, at least, who are the ones who are going to be seeing this, are working for the U.S. government. And state and local government employees, which many of us are, public librarians, public school librarians, academic librarians at public universities. It's a little more of a gray area. It can depend on your state law, and also sometimes on what the work is and its purpose. But if you're an academic librarian at a public university and you create a LibGuide for your library's website on biology resources at your library, that could be considered a work for hire because you're creating it just totally as part of your job. But if, on the other hand, you wrote an article for the ALA's American Libraries magazine about the creative way that your library uses LibGuides to help biology students, that would usually be considered a work for which you would hold the copyright, unless you assigned the copyright to American Libraries magazine when it got published. So it's complicated. Like all things to do with copyright, right? It's complicated. It's a gray area.
Well, and what about if you're at a private institution?
Private institutions, it's more, actually, it's not more or less likely to be a work for hire. It's going to depend on how your institution views it and what their policy is. Now, most institutions of higher education, as a matter of policy, do not try to claim copyright in the articles that their faculty or employees are writing, because people would leave in droves. You know, we want to own what we write, don't we? Right. If you were a professor, though, and you were creating materials for an online course as part of a special agreement with your university where you knew that this online course in the future could be taught by somebody else using those materials, that's going to be a work for hire. You're probably not going to have the copyright. Now, you might have an agreement where you could still use them. So if you left and took a job someplace else, you could continue to use those materials also, but probably your university would claim the right to continue using them as well, if that makes sense. So, and that comes up pretty frequently, and it's coming up more often. It was a matter of discussion with the faculty at my university this year because of everybody moving online to teach remotely with the COVID-19.
At East Central University, where I work, we have a lot of programs that are transitioning to be online only, even before coronavirus happened. And So we've had a lot of discussion with faculty, and Faculty Senate has been working on creating a policy that the admin agrees to and that the faculty are satisfied with. So it should be in an official document somewhere, you know, at your institution, whether that's like the faculty handbook or some other document. So are copyright laws applied differently to online classes than in-person classes?
So as a general rule, the format doesn't matter. That you know, if you're copying something, it could be potentially an act of infringement, whether you are distributing it but in practical sense, it does matter. As we mentioned earlier, we've seen the Teach Act legislation, and part of the reason behind Teach Act and Digital Millennium Copyright Act is because it frankly frightens the copyright owners because digital technologies make it easier to copy and distribute materials, and so and we saw that, of course, with file sharing in the 90s and 2000s. And so because the Copyright Act has not been substantially revised, we have these amendments that make it that do make a difference between in-person and digital. So some parts of the legislation apply to face-to-face classes, like the law explicitly permits instructors in face-to-face learning environments to show entire films to their classes without requiring a license or permissions. When it comes to showing a film to a class, a distance education class, it's not, the law itself does not explicitly state that it's permitted. And so we are put in this position where we have to parse through these multiple complex acts to determine, can I show the entire thing? And I don't know how in depth we want to get into all of that now, but you know, I'm prepared to discuss the nuances of screening films over the internet. But uh, the same thing applies with handouts. So it's explicitly permitted to make handouts within fair use parameters. But when it comes to doing so digitally, there are some additional restrictions. And part of those also have to do with how the original item was accessed, you know, whether it was scanned or whether it was accessed through the library databases. So we have a lot of different layers that we have to cut through. Depends on, you know, what the whether the students have access to it outside of the course management system. To what extent is the professor needing to, quote unquote, circumvent technological measures? In other words, if you have a DVD, can you just take portions of it and place it into the course management system? The law is not entirely clear on that. There is an exemption to the Digital Millennium Copyright Act, explicitly allowing short portions to be of a DVD to be uploaded or screened, but that term short portions is not defined. So we're really not in a position where we can give unambiguously clear, you know, and feel like we're on safe legal ground. And that's why it's important, a theme I'll most likely come back to multiple times, to have a kind of partnership with your university's legal counsel, with faculty senate or faculty council, with your teaching and learning centers, to come to a decision that doesn't freeze us from making content available that's important for the educational objectives of the course, but still respects the rights and the licenses that we're required to abide by.
You mentioned that usually fine to hand things out if you have a face-to-face class. If you have like a handout, you can spread that, around to everyone. Let's say if there's a faculty member who has an article they want to share with their class, if it was a face-to-face class, it would be fine for them to share that, to print it out and share it with their class? Is that correct?
It's the mantra of anyone giving copyright advice. It depends, right? So so let's say it's a, so is the question about a scanned item, or was this, or just in general?
Yeah, let's say it was a scanned article, like from a print periodical in the library.
Right. So in that case, you're most likely going to be in the clear if you hand out a printed scanned item from a scanned paper item, as long as it's within fair use. If it's an article downloaded from the databases, most likely too, you're going to be cleared for that, because the license agreements that we sign with the libraries sign with the vendors and the publishers allow for that, but not all of them. So
right.
For example, the kind of quintessential example here is Harvard Business Review, where they don't even allow anyone to link to their articles in their online electronic database, let alone provide access to them. And so it's really important to be very conscious when you're downloading items, to actually read the fine print and know what you're permitted to do with it or not.
So I guess that would be true for an online course too. If you've got an article from a database or from an e-journal that the library subscribes to that you want to share with an online class, it really depends on what the license agreement is. Right?
Well, if it's an article in a database or from an ebook that the library has a subscription to, the best way to share that in an online class would be to provide the link to the students. And then the students can just go directly there, read it online, download it, print it, whatever the database is allowing them to do. That way you don't have to worry about printing it or making a copy or whatever. That's what those wonderful agreements are for, is to let the students use them. But in general, if you want to connect students with information, if there is a link that you can give them to that information, give them the link, because then if there's any problem with the item at the link, like you link to a YouTube video and it turns out to have been uploaded illegally, that's not on you. That's on the person who uploaded. All you gave them was the link. You did not personally share the file. So links, always good. If you have a choice, use a link.
And that gives the libraries good usage statistics, so we know.
Yes. Yeah. If somebody saves a PDF of an article and shares that on Blackboard, the library only gets one use from that. If the faculty member shares the link to the article, every time a student goes and clicks to get the full text, that's going to be another usage statistic. Yes. Love those statistics.
Also true, yeah.
So how about images? Is it okay to use images and graphics that you find online, as long as you say where you got them from?
No, that's that assumption of public domain thing I talked about right at the beginning. If you find an image or graphic and it is labeled as being in the public domain, or it has a Creative Commons license attached to it that permits it to be reused, then you're fine. But if it doesn't, then the context that you're using it in matters a lot. If you are going to take this image and you're putting it into, say, a PowerPoint, which you are going to show in person in a face-to-face class, you're not going to make that PowerPoint available electronically afterward. Your use actually falls under the educational exception to the copyright law, and you're fine. That is an educational use within the classroom. You're at a nonprofit institution. You are okay. If you're using that image or graphic in an online course, you would want to go through that handy dandy list of 5 questions that I have. Look through the Teach Act and see if your use is permitted by that law. If not, then you want to go through the fair use conditions and decide if it would fall under fair use. You should always attribute the source, of course. I mean, just as good practice and ethics. If you are making it available, online in a permanent form, think twice before using something that is under copyright, because if it gets shared out on the general web, then you could be in trouble. So if you're making a presentation at a conference and it's live, you're okay. If you're making a recorded presentation like this one and people can get at it afterward, it might not be okay. So.
Yeah, so if you're just looking for images to liven up your slides, there's a lot of really good Creative Commons licensed images out there on Flickr. You can do a Google image search and limit it to Creative Commons licensed. So really, if it's just to enhance your presentation, use Creative Commons just so that and you're in the clear. And I know a lot of people like to use memes, like funny memes, clips from movies and so on. It's a kind of gray area. It's a short portion of a film, so you could potentially say it's okay, but maybe, as Chris had mentioned, in class, okay, but if you're putting it out on the web, maybe just link to it. And the same is true, if say it's a plot in a journal article, like a table or a plot that really is important to your point. While you're in person lecturing, you can put it, but otherwise just link to it. That way you can be kind of calm and certain that you're in the clear.
That does have the plus, if you are careful to begin with, to use stuff that is public domain or has a Creative Commons license on it. If you're creating this for an in-class use and you decide later to record it, or you teach an online class next semester, then you don't have to worry. You don't have to go back and find something else to replace it. So, if you just kind of do it the safe way to begin with, that can be.
That's a good point. Yeah. Yeah, and there are, Creative Commons has tons of great stuff, but there's also a lot of free public domain stuff that has no copyright attached to it out there. It's pretty good too.
Yeah, absolutely. And also remember, if your institution has image databases like ArtStore, a lot of times those are explicitly licensed for use. But again, you have to abide by the terms of the license.
I believe the Getty Museum made a lot of its images available fairly recently as well. So some of the big museums and repositories.
The Smithsonian has some of
that. Are increasingly making some of their images available. So if you have professors in art history or even literature and some of the other especially the humanities, who might want some, really nice artistic images in their lectures and whatnot. Those can be places to find some stuff that is usable without concern. You have to attribute, you have to do whatever, but they're at least free, and you don't have to write to somebody to ask.
Right. So the TEACH Act has been mentioned a couple times. Can you guys just give us a little rundown on what that is?
Sure, can tackle that one. Let me. Actually, Kristen, would you mind starting my notes closed? And I need my notes when I'm talking about the TEACH Act. No, I think you're muted.
Oh, you're muted, Kristen.
Sorry, I'm not sure I have it right here either. The TEACH Act was passed in 2002, and its purpose was to make explicit the terms under which certain types of copyrighted material could be used in online education, essentially. And it's fairly complicated. There are a lot of specific conditions that have to apply, like the institution has to be a nonprofit educational institution. So a for-profit online college does not actually qualify under the TEACH Act. So someplace like the University of Phoenix doesn't actually qualify. But Casey's institution would, because they're nonprofit, even though they're starting to do a lot of stuff online. That's still a nonprofit institution. And you know, the institution does not have to be entirely online in terms of its education. It can be both, but the TEACH Act would apply to any courses that were being offered online. Clark, do you want to add some more of the conditions?
Yeah, sure. So it's not something, the TEACH Act is not something that you must refer to first when you're trying to decide whether or not it's permissible to share something with your distance education students. The idea of it was to harmonize. So it replaced a portion of the original copyright law that was not workable for online environments. And it tried to harmonize online with in-person. So really that's the thing to think about, is the intent was to make everything that was allowable in person to be allowed online. But because of what I mentioned earlier, content creators having this concern that people in education were all of a sudden going to engage in mass piracy, and being sarcastic there.
Educators are now pirates.
Right. Well, they put in all of these conditions that you have to meet in order for something to be considered as protected under the TEACH Act. So was it lawfully acquired? Yes or no? Initially, you think that's pretty simple. If I buy it, if I check it out from the library, it's okay. If I download it off of some pirate website on the internet, that's not okay. But then, as I mentioned earlier, what about taking a portion of a DVD that you did lawfully acquire? And so the TEACH Act works kind of interlocked with the Digital Millennium Copyright Act, which every few years introduces exemptions into it, which a few years ago that was permitted, as long as it's in short portions and so on. So other conditions that have to be met for something to be protected as part of the TEACH Act: is it directly relevant to the educational goals of the course? Is it accessible only to students enrolled in the class? This was a big one. Was it originally created for use in online instruction? And so the idea there is that they didn't want it to compete with online textbooks. So that's something that you have to check on, because obviously they want students to buy the online textbook rather than have access through the course management system. Was it in an amount comparable to what you would typically display? And so here, here's where we start getting into film screenings. So if I was to show a film in the class, the students come in, they watch the film, and they leave. Whereas if I was to post a film or portions of a film online, that's going to be available to them throughout the duration of the semester, or if they download the file, far beyond that. More exemptions, I mean, we can just keep going on and on. Is it a non-dramatic literary or musical work? So here it's allowable if it's a non-dramatic literary work. In other words, it's a novel or a poem. I know you think a poem isn't that dramatic, but drama here is meant literally, like for theater. So it's allowable if if the narrative is told through dialogue and action, that's dramatic, like theatrical performances, whereas non-dramatic is reciting text. I don't know. Do you want me to keep on going, or is that a good stop?
That's probably good. It's good amount.
I mean, sort of in short, you could say that the TEACH Act, although it was supposed to make it equal between online and in-person courses. The Teach Act now has so many kind of restrictions and hedges around it that it is harder to use materials under the Teach Act for online stuff than it is to use something in person, and probably you're going to be better off looking at fair use. On the other hand, if you go through the Teach Act and you say, okay, this use is permitted under the Teach Act, then you know you're fine. There is no question of the legality. There is no maybe, maybe not. You know for sure you're okay. So it's worth looking at, because then it's one of the few times you can be certain. If it actually falls within all of those parameters under the Teach Act, you are legal.
So let's talk a little bit about using fair use as guidelines for deciding how much can be used. So like, what are the 4 factors of fair use weighted in evaluating the use of material?
Okay, well, the 4 factors for fair use are it's the purpose of the use, the nature of the work, the amount being used, and the effect that this use will have. And so again, I have that lovely handout which lists all of these and then gives some factors that might favor fair use or oppose fair use in each of the 4 areas. So for example, if you are considering using something, the purpose, if you're using it for teaching, that is definitely something where teaching falls into the favoring fair use. If you were using it just for entertainment, no, not so much. So this is why the Teach Act specifies that, you know, if you're showing a film, it needs to be pertinent to the class. Unfortunately, you aren't really supposed to go in and show a Monty Python clip just to entertain your class. I have to confess I did that a couple of times when I was still teaching history, but it was in person at least. I was not uploading files or anything like that.
Well, if you were teaching an online course and you wanted to do that, what if you linked out to a YouTube video?
That would be fine. Like I said before, linking out, you're always going to be okay, because if there's any problem with the copyright at the link, that's not on you.
Right.
Fair use, the nature of the work. If it's published, clearly the creator of the work wanted it to be out there and be used. If it's factual, if it's nonfiction, if it's important for favored educational objectives, those would all be within the nature of the work promoting fair use. If it's an unpublished work, if it's a highly creative work, so a novel or a play or a film or whatever. Fiction in general is creative, right, in a way that nonfiction is not. I mean, the author has to organize the nonfiction article, but it's not completely made up, and so we place more value on something that is completely made up by the author. The amount that you're using, and we've already touched on this when we talked about the 10% rule of thumb, a small quantity, something that is not the absolute heart of the work, and that the amount is appropriate for the educational purpose, as opposed to the whole work, or you're using the heart of the work, or you're using a lot more than you really need to get this across to your students. And finally, the effect. If the user owns a lawfully acquired copy, that's going to be favoring fair use, as opposed to, you got this great pirated video or something. If you're only making 1 or a few copies as opposed to numerous copies. So yeah, you're copying it for each person in your class, but you're not making 500 copies and handing them out outside the cafeteria. I don't know why you would want to, but in case. If you're not having an effect on the market or the potential market for the copyrighted work, so if this is something that is out of print and you're doing 1 chapter from it and there's really no reasonable way you could expect your students to buy the work, that's going to favor fair use, as opposed to, gee, this is a Penguin paperback and they can get it for like $8. Then you probably should just have them buy the book. So you can't even say that one of these factors is most important. It's going to vary. It depends, right? It depends always.
Depends.
It's going to vary on the specifics of your situation, your class, exactly what work you're using, how much of it, etc. So, but those are the things you want to be thinking about is what are these factors? Does my use favor fair use or would it be opposed to fair use?
Are there any recent judgments or changes to copyright law that we should all be aware of that you guys want to share?
I do have one, but I wanted to just add something real quick to the fair, which that was a fantastically succinct but detailed description of fair use. But I mean, I really think that we should be approaching fair use proactively. Like it is there in order to help achieve the constitutional purpose of copyright law using intellectual property to create intellectual property, basically, and to exercise some of our other constitutional rights, like free speech. In order to do that, we have to be able to make use of the content that others create.
Right.
And that would the benefit, the social, cultural benefits of using the content be greater than the costs that are imposed on the copyright owner. In other words, kind of would allowing this use go further towards promoting the goals of copyright than disallowing the use. So it really needs to be a tool that we wield. But it is also important to say that there's no way that we can say, yes, definitely this is a fair use. Like only a court, only a judge can say, yes, it's fair use or not. But we can make our own fair use assessments. And to the extent that we can document those, that we're making a good faith effort to abide by fair use. And indeed, I mean, document literally. The University of Minnesota provides a thinking through fair use tool that really, and there's several out there, and Kristen has linked to some of those as well, that kind of help you weigh out the factors for yourself. But if you have that and if you document it that way, if some lawsuit happens, which we shouldn't be making our decisions based on a fear, oh, I might get sued. But as if something were to happen, if you have that documentation, then at least you wouldn't be as liable for as much damages as if you didn't have that documentation.
Right. And I mean, one of the great sort of myths and fears is that publishers are all out there searching for people that they can sue. Your average professor, nobody knows, nobody cares. To be perfectly honest, the Georgia State case that Clark referred to earlier, that one was a big deal because in that instance it was like the whole university and it was the library's online reserve system and their course packs that they were producing. It wasn't just one individual professor or a few professors deciding to jump one way or the other with respect to fair use. So it's really quite uncommon to be sued if you are an educator, as long as you're using it within the context of teaching your class, even if it's online. I mean, you want to follow the law, definitely. I'm not saying to ignore the law, but don't fail to use something that is pertinent and useful for your students out of a fear that you might be sued for copyright infringement. Like Clark said, use that fair use. That's what it's there for.
So any recent judgments that we should know about? Changes to the law?
So in March of this year, actually, right as everything was starting to fall apart, there was a case called Allen v. Cooper, and not going far into detail, but a videographer took footage of Blackbeard's pirate ship, the Queen Anne's Revenge, being salvaged, and the University of North Carolina posted that footage on their website, and they were sued for infringement. And the interesting outcome of this case was that it found that universities could not be held liable for copyright infringement. Effectively, they have sovereign immunity when it comes to copyright infringement specifically. So this is really, I've read a couple of articles about it, but I am by no means able to give a good interpretation. In fact, most of what I'm saying now is based on an article I read by Kevin Smith, who's kind of one of the foremost copyright educators in the country. And what he said about it was that it doesn't mean that we can just say, oh, so universities can't be sued or held liable for copyright infringement. Let's just post whatever we want. Of course, he's not going to say that. And he's not even necessarily saying that we can worry less about it. But it's kind of like there's potentially another layer of protection there. The publishers still would have a way of bringing a lawsuit. With the Georgia State case, for instance. Georgia State was not the defendant. I believe the provost and maybe the library director, they were the ones named in the lawsuit. So there are ways that if publishers are particularly vehement, and also with Georgia State, they chose to fight that, to kind of say, we're standing up against this. If you're at an institution that is more risk averse and publishers send some kind of injunction, most likely they'll say, yeah, we'll do it. We're not going to go to court, especially because this case is now drawn on for over a decade. But I guess, I think that copyright lawyers are still trying to figure out what implications this case is going to have. But it's fascinating as part of the case law that specifically with copyright infringement, sovereign immunity applies.
That was interesting. I don't really know anything much about that one. I think I might have barely heard of it, but I haven't really read up on it. So thanks, Clark. I think I'll have to go and look for something on that now. One thing I wanted to mention, though, was since practically I can remember, certainly for basically my entire professional life, we had this, okay, public domain, anything before 1923. That finally came to an end a couple of years ago, and there is now a moving wall of public domain. Once again, Mickey Mouse has been conquered. So in 2019, works published in 1923 came into the public domain. The beginning of 2020, works published in 1924 came into the public domain, and it will keep going unless Congress does something stupid and extends it again. Like I said, I think that would be a terrible idea. But this does mean that all of my old handouts, which just always said, okay, anything before 1923 is public domain. Now I'm going to have to update them and say, okay, you need to count back this many years, or give some examples so that they can calculate easily. So things that were not previously in the public domain now are, and this will continue. So if you are a cheapskate like me and you like to get free books for your Kindle for stuff that's in public domain, for a long time, I could only have Agatha Christie's first 2 published books because those were the only ones that had been published before 1923. And I think there's now 1 or 2 more I could get. So
Nice.
Something to be aware of. Public domain is actually expanding once again. Hurrah.
And that's a great example, and something really amazing that happened with that is a lot of people really began using that content in new and interesting ways and building on it, making comics with it. And
you could make an OER with it.
That's right. That's exactly right. And this quote, I think this was from Cory Doctorow, who said, when he grew up, every story he wrote was Star Wars, but eventually it started building into his own kind of ideas. And that's really why we need a moving public domain, because let's be realistic. The people who come up with this content aren't doing so in a vacuum. They're borrowing from all of this other cultural context that really does belong to the public, even if we give this temporary monopoly so that artists can support themselves and so on. It really is benefits us all to see it as sort of a public property rather than the property of the creator going on, hundreds of years into the future.
Yeah, I think for a work by an individual author right now, it's the life of the author plus 70 years. And for a work for hire, it's 95 years. And, frankly, if it's life of the author plus 70 years, why does their grandkid need to be profiting from the work? Honestly, this does not make sense. It just doesn't make sense. So.
Let's talk a little bit about reserves. So what are some of the copyright differences between a print reserve and an electronic reserve?
So print reserves, you can generally place portions within fair use on print reserves. You can put entire books on print reserves, obviously, and allow students to check them out, just in the same way that we can do with regular materials. If we have to be careful if we're compiling like in course packs, or if we are putting lots of different material together in a way that's arranged exactly the same way as published anthologies, that could potentially run up against some potentially infringing. But we're pretty good when it comes to making print materials available. We put a copyright notice on there, and basically don't compete with the books in the bookstore. In other words, the market for the work. But when we're coming into e-reserves, we're more restricted. We should try and limit ourselves to smaller portions. It should be directly relevant to the course objectives, so optional readings shouldn't be put on course reserves. And as Kristen mentioned earlier, generally if the link is that exists, then that's the best place, the best thing to provide. Really, if you are using portions of a work, you can scan it in. I mean, sorry, I'm lost my train of thought. The instructor is responsible for conducting a fair use assessment if it's a portion of a book. And yeah, I think that's all I have on that one.
Do you have anything to add, Kristen?
I mean, I would just note that one of the reasons why online electronic reserves you have to think a lot harder about is because they can be accessed by many people simultaneously. You have a print reserve, only one person is using it at a time. And also the electronic stuff is usually in a file format that can be downloaded. It can be reshared with just a few mouse clicks.
So you're relying on the user to also follow the rules.
Right. Right. I mean, I think most of us probably have a notice somewhere on or near our photocopy machines that says something about like, this is the law for copyright. You are responsible for not infringing. Make your decision. We, as I mentioned, my school has a big music program, and so students will do things like request scores through interlibrary loan, and they will come and pick them up. And I see them walk over to the copier and they come back and they return the item, 15 minutes later. I do not
even subtle about it.
What they have been doing. I can't ask. I don't tell me this is what you're doing. I'm not supposed to know. You're not supposed to be doing it. But I can't stop them. All we can do is warn them. They are responsible. If the publisher of that music ever came after them, it would be on the student for having ignored the copyright notice. But we all know they do it. All we can do is discourage. And I do know that our music librarian and the faculty in our music department do a good job of emphasizing to the students, don't do this, really don't do this. That doesn't mean the students listen, but I know that our librarian certainly, you know, she orders multiple copies of things so that multiple copies can be checked out at once,
Right.
stuff like that. But yeah.
And the point that Krista made there about simultaneous use has been in the news recently. You may have heard that the Internet Archive relies on a
Right.
theory of lending where if they hold the physical item, they can make an electronic copy of that available as long as it's only temporarily available. And in other words, it's wrapped in what's called digital rights management, where the user checks it out and then it expires off of their computer after a certain period of time. Well, when the coronavirus began, they said there are so many people who cannot access libraries now, so we're going to lift that one book, one lending, and allow as many people who want to lend it simultaneously as possible, unlimited. Effectively, it will still expire off of their computer, but it's unlimited users. There's no longer a correlation between having one item, one physical item, and one electronic lending. And they've been sued by several publishers for that. And they, as a result of that, have ended. Well, they didn't say it was a result of that, but they have since ended that. But it's something to consider here with simultaneous use. That has not been tested in law, the whole idea of controlled digital lending. But not only did the publishers challenge the Internet Archive's right to make unlimited copies available, they're also challenging their right to do controlled digital lending at all. So it'll be interesting to see where that goes.
Yeah, let's actually talk a little bit about how COVID-19 has affected everything. Talk a little bit about what changes have been implemented at your institutions regarding distance education in the next year, or what we at least are planning for the next year, which may change because plans keep changing, you know. But what kind of copyright issues have been coming up for you guys?
Well, I had, you know, fairly soon after we closed our campus and went to remote instruction, I had one of my liaison area faculty get hold of me and say, I was going to show these several educational DVDs in class, you know, in the next few weeks of the semester. Help, what can I do? These were, as I say, educational films. This wasn't something that you could say to the students, gee, you know, shell out the money and get Netflix and you can stream it. In this particular instance, I think it was 4 different films this faculty member wanted to show. One of them, it turned out we actually had a streaming subscription to through the Academic Video Online Database, Avon. And so I was able to say, hey, here's a link.
Here's a link. Yay.
They can watch it, you know, with you if you're doing synchronous instruction, or they can watch it whenever they want if you're doing asynchronous stuff. And the other 3, unfortunately, we didn't have. I could not find, you know, a streaming source for them anywhere. You know, obscure educational stuff. And this was an education course. I mean, so this is really pretty limited audience type things. I was able to search the Avon database and find a few other titles that were at least related, had some similar information. And so I think the professor was able to use some of those. Right now, looking ahead, my campus is planning to offer at least some and perhaps most, and this will probably depend on the professors and the departments and the schools, but some classes in what's called the high flex format, hybrid flexible, which if it's fully implemented, it allows students to choose whether to attend class in person or asynchronously online, and they can choose on like a day-to-day basis if they will turn up in person or if they can complete the material online asynchronously. But that means that everything for the course has to be available online. So readings, film or music clips, everything. This is still in the planning stages. I'm in one of the learning communities that's working on how to do HiFlex well. So just kind of make sure that people think about copyright and talk to me if they're not sure so that I can give good advice. Especially since some of these instructors probably have done very little, if any, online teaching before other than this spring where it was like emergency and they weren't really teaching online, they were just doing remote instruction, which is a different thing, honestly. So we don't have a lot of firm guidelines yet, but it's a small enough school that we can do it on a more informal and case-by-case basis, I think. Than is probably the case at some place like OSU, which is much, much, much bigger.
I mean, as a library, the first thing you want to do is to see if you can get the license for it, right? Because then you know you're in the clear. But as we know with ebooks, like especially if it's an assigned ebook, the students are all going to be accessing it the day before. And so most of our ebooks are single user license. And a lot of professors don't know that. So one of the first things to do is education and say, don't just pop a link up on Blackboard, but check with us. But then, you know, you can buy a 3-user license and that might be $600. And then you can buy unlimited user license and you're talking for a single course, we're talking thousands of dollars. So that's really just unrealistic. So, I mean, that's a big challenge. And you want to be able to say, it puts you in a dilemma, and it really comes down to a risk assessment and how risk tolerant are you as an institution, how much formal and informal guidance do you want to say you can put more, you know. A question that I have that I don't really have a good answer to is, do the current conditions that are forcing us to work online give us more flexibility and fair use? I mean, I think you could make a legitimate argument for that, although, you know, publishers may not find it convincing.
Right. Yeah. I want to ask you guys too, like, what can librarians do to help faculty who are facing a lot of these questions? I mean, I know a lot of faculty members who are being forced to try to figure out how to put their course online, and they've never taught it online before. So they're struggling with all of these things. What can librarians do to help them?
Well, the first thing is for the librarians to educate themselves, and hey, watching this presentation is a good place to start. Be proactive. Like Clark was saying, you know, think about the problems that they might run into and try to make information available on copyright, on possible issues, on ways that they might be able to resolve those issues effectively. And especially information on determining fair use, because that's the most expansive use for copyrighted materials. So create a nice online guide that you can point them at so you don't have to answer every question individually, or you might send out information by email. Maybe if you create that guide, you want to send a little message to all your faculty saying, hey, we have this information available. Here's the link. You can go and look at it. If you have questions, contact me. And be ready to answer those questions, because professors, like students, may wait until the last minute. And suddenly, you know,
Yes.
the day before classes start, you will get 8 people saying, I need to do this, can I do it? And then you need to try to help them.
Right.
Yeah, those are all great suggestions. And something else that hasn't come up directly is open educational resources, which are materials that are openly licensed. I'm sure we're all familiar with OERs at this stage, but it can be really challenging to find good open educational resources. And that's also where our expertise as librarians come in, where potentially helping to piece together, maybe use a textbook here, but then you can find a question bank here.
Sure, yeah.
Yeah, looking for alternatives.
Well, I think that is pretty much it for our session today. Thank you both, Clark and Kristen. This was a really great discussion. And thank you guys for anyone who's watching this video. If you enjoyed it, if you found it useful, you might want to consider joining the University and College Division of OLA and connect with other librarians and have discussions like this. And don't forget to fill out a session evaluation for the conference for this session. And there is actually another session on open educational resources that you might want to watch in addition to this one. So thank you, everyone, and that's it for today.